Welcome, everybody. I see people popping in. Opened up a little bit early today. We'll start in earnest as close to 3 o'clock as possible, but I wanted to give people time to get in and make sure that your audio settings are correct and you're familiar with our controls here. Zoom should be pretty familiar to everybody by now. Great prompt turnout today. Thank you all. All right, I have 3 o'clock, so I will at least start my introductory remarks. Welcome, everyone who's with us today. My name is Matt Shepard. I'll be moderating this session on the new observation status appeals. Our presenters today are Center for Medicare Advocacy Litigation Director Ali Bears and Senior Attorney Weiwei Kwok. Before we hear about a center a little bit, bear with me. We'll do a little housekeeping here. As with any online presentation, your audio or video connectivity is going to be at the whim of your internet. So you want to make sure that you are well established there. You definitely also want to make sure that you've got the right microphone and speakers set in the audio controls. That would be down at the lower left of your Zoom screen. And should you have trouble watching or listening at any point, do note that registrants will receive a link to the recorded presentation in a follow-up email from me. We hope to have plenty of time for Q&A today on that topic. Please note that Zoom has, in addition to our regular chat window that I'll mention in a second, a questions button. You can pop up the Q&A section and type questions right in there. I'll monitor those and pass them on to Ali and Wei when we hit the appropriate time. We can also do the old raise your hand and I can unmute you as well. On the topic of the regular chat, Jeff Wiseman will be monitoring that today. You should be able to chat with anyone or everyone at this point, so say my settings. You can see Jeff has a welcome in there, and I've also added some of today's resources in case you didn't receive them when I sent them out earlier today. That would include a resource page, a flowchart of the appeals process, a copy of the required notice we'll talk about today, and a copy of the retrospective appeals form we'll talk about today. And when you do check that chat, say hello to us. Let us know what state you're from, what organization you're with, if any. We're almost there. Now, though, a little bit about the Center for Medicare Advocacy very quickly. The Center is a nonprofit law organization that works to advance access to comprehensive Medicare coverage, health equity, and quality health care for older people and people with disabilities by providing exceptional legal analysis, education, and advocacy, all based on the experiences of real people that contact the center every day. Thank you all once again. Now let's welcome Center for Medicare Advocacy Litigation Director Ali Bears to really get us started today. Ali.
Great. Thank you so much, Matt. We are very happy to be giving this webinar today. It's been a very long time coming, and we have been litigating and waiting for these appeals for over a decade. It is a pleasure to finally be able to present some concrete information about the appeals that will be available starting in the new year. So we'll be discussing the problem that Medicare beneficiaries were facing, the class action lawsuit that we filed to address the problem, and now the implementation of the decision in that lawsuit. There are two types of patient status appeals that will be starting in 2025, which we'll be reviewing, and we will try to leave some time for questions at the end. One disclaimer I want to say up front is that my colleague Wei Wei Kwok and I are class counsel in the court case. We represent the Medicare beneficiaries who are members of the class. So this webinar is geared toward giving information to beneficiaries, that is, to patients or their families or other people who help them. We cannot give information or advice to medical providers about compliance, about billing, or other technical issues. Providers will need to consult with their own compliance personnel or legal advisors. That said, as part of the basic overview of these appeals, you'll see that medical providers can assist beneficiaries in certain ways when they're appealing, so the information in this webinar might be of interest to providers. And also on that note, since we're aiming this webinar at beneficiaries and people who help them, we're trying as best we can to stay away from jargon and the alphabet soup of acronyms that you so often hear in Medicare. Some of it is unfortunately unavoidable, and the topic here is somewhat complicated just by its nature. So we're trying to present it in understandable terms. If you do not understand something that we say, please do go ahead and type your question in the question box and we will try to answer it. For the lawyers in the audience, some of the slides do have citations to cases or regulations at the bottom. If you're not a lawyer, feel free to ignore those. And also bear with us because these appeals and regulations are brand new and we are learning them as well. So if there's something that we're still trying to figure out when you ask a question, we'll be happy to get back to you when we do. Okay, so bear with me as I proceed on to the next slide here. Sorry about that. Okay. So since you signed up for this webinar, or if you've worked on Medicare issues, you may be familiar with observation status and the problems that it can cause people who are hospitalized. Observation services are given to patients who are considered outpatients, even though they're very often on a regular hospital floor, same type of bed as inpatients, given the same food, wearing the same gowns in the same rooms. You wouldn't know that people in observation are not inpatients. And the real problem can happen if the patient requires care in a nursing home after a hospitalization. It's a common situation. People often need to go to a nursing home after they're in the hospital to get their strength back. They may need some physical or occupational therapy and some skilled nursing. But Medicare requires a 3-day inpatient hospital stay to cover the nursing home stay. And time spent in observation status does not count towards that 3-day stay. So you get this 1 + 2 does not equal 3 problem. You can be in the hospital for 3 days or for longer than 3 days and still not have a 3-day stay that qualifies you for a covered nursing home stay because you did not have 3 days in a row as an inpatient. Also, if you do not have Medicare Part B, you would not have coverage at all for your hospital services. There aren't too many people out there without Part B, but they are out there. And because observation is considered an outpatient service, outpatient observation services, which are covered, outpatient services are covered by Medicare Part B, not by Medicare Part A. If you don't have Medicare Part B, you would have no coverage of your hospital services, and you might be responsible for the full sticker price of those hospital services. And Medicare has not allowed patients to appeal the issue of whether they were properly categorized as inpatients or as outpatients receiving observation services. Many people have had to forego care because without Medicare coverage, they couldn't afford to pay for a nursing home themselves. Or if they did go to a nursing home, they pay thousands of dollars out of pocket and they had no way to appeal. So we at the Center for Medicare Advocacy, along with our co-counsel at Justice and Aging and our pro bono partner, Wilson Sonsini, Goodrich and Rosati, that law firm, litigated a class action. There were 14 individuals around the country who are plaintiffs who had experienced this problem, who we represented. And in the case, we won the right to appeal the observation status classification in some circumstances. The case has a very long history. You can see that filing date way back in November of 2011. The ultimate decision of the court was that Medicare violates the constitutional rights, specifically the due process rights of class members by not allowing them to appeal their placement in observation status. Now, the court did narrow the group that the decision applies to. So in the end, it is a subset of the affected group who can appeal. The main limitation is that the class is limited to people who are admitted as hospital inpatients and then reclassified by the hospital as outpatients receiving observation services. So why did the court limit the class this way? This has to do with constitutional law and the due process doctrine. To make a very long story short, there's a requirement of government action for a decision to be protected by due process and subject to rights like the right to appeal. And the court found that the government action is limited to those reclassifications when the hospital staff is essentially conforming the patient's status to standards that Medicare dictates. It did not find the government action when a physician is admitting the patient as an inpatient. Believe me, there was a tremendous amount of argument and evidence and briefing on this topic. This was the way, excuse me, that the court came out. So what we have is a subset of people affected by the issue who have appeal rights. Excuse me. It's not as large a group as possible, but it's very important for those who do fall in the class definition and they can appeal. The court ordered Medicare to create appeals processes for all class members dating back to January 1st, 2009 and going forward indefinitely. So as you'll see, some people will be eligible for retroactive appeals and going forward, people will be able to make use of prospective appeals. I'll go into detail on that in a minute. So moving on to implementation. Retrospective appeals are for class members who did not have a process available at the time their rights were violated. This is mostly going to be for people who had to pay out of pocket for nursing home services. If they succeed in these appeals, they may be able to get a refund for those out of pocket costs. And it will also be useful for the small number of people who did not have Part B who can obtain refunds of hospital costs. These appeals will cover a closed period. They will cover hospitalizations dating back to January 1st, 2009, and they will go up, they will cover up to the point where the prospective appeals will start, which is February 14th of next year, 2025. So you can think of these as sort of the makeup appeals for the people who could not appeal at the time because there was no way to appeal at the time, and this is kind of the makeup process for that. Then there's the prospective appeals for class members who are in the hospital and want to appeal their reclassification from inpatient to observation. These are going to be quick appeals, and they'll be most useful for people who need nursing home care after a hospitalization, but who do not have the 3-day inpatient stay. If they succeed, they will be able to get the qualifying 3-day inpatient stay that can make them eligible for Medicare to cover their nursing home stay. And this means they may not have to go home without nursing home care they need or spend thousands of dollars just to get in the door of the nursing home, which is what we often see happen when someone comes without that 3-day inpatient hospital stay. These will be available starting in mid-February on an ongoing basis. So I'm going to provide an overview of the retrospective appeals, and my colleague will be providing an overview of the prospective appeals. In general, keep in mind that the court said that these appeals that it has ordered are supposed to be largely similar to existing Medicare appeals. Both the retrospective and the prospective in general, both are going to be largely similar to existing Medicare appeals. And I take that as both good news and bad news. The good news is they'll be similar to existing Medicare appeals. The bad news is they'll be similar to existing Medicare appeals. For those of you who are familiar with the Medicare appeals process, it has its difficulties. It's not the easiest system to use. Sometimes we have problems with the way decisions are decided. On the other hand, it is the system that we have that we are used to using already. We're not getting anything better or worse than what exists. And now we do have appeal rights in that system. And you'll see essentially the same appeal rights where you can appeal up through the levels. And as we often find with existing appeals, you generally have a better chance of succeeding the higher you go in the system. So that's sort of my overview and sort of editorial comment about the Medicare appeals system. Going on to who can request and who is eligible for the retrospective appeals. This slide reviews who is eligible. I've paraphrased it. This is probably the hardest slide in this webinar. Even as a paraphrase, it's confusing. But to run through it, people in traditional, this is who is eligible. It's for people in traditional Medicare. So this does not apply to people in Medicare Advantage plans. People in traditional Medicare who were reclassified from inpatient to observation on or after January 1st, 2009, and they received a notice showing the hospital was not covered by Part A. That notice could be either a Medicare summary notice, that is the routine notices that people in traditional Medicare get in the mail showing the services they got and the coverage or non-coverage of those services. They're received in the mail. They can also be retrieved online through a My Medicare account, which you can set up if you don't already have one. That could be the notice that's received, or you could have gotten a MOON, Medicare Outpatient Observation Notice, which would have been given to you by the hospital. For the last several years, hospitals have been required to provide MOON notices in certain situations where people are getting observation services. So those would be the two types of notices that you might have gotten. So then if you meet those criteria, then you have the either or. And these are sort of the two groups. These are sort of the two most important, groupings that I think of. Either you have sort of group one, which I think of as the nursing home problem. You stayed at the hospital for 3 days, but you were an inpatient for fewer than 3 days, and you were admitted to a nursing home within 30 days after leaving the hospital. So that's the group that, if they hadn't been switched to observation, they would have had that qualifying 3-day stay and been able to get Medicare coverage at the nursing home. Or the other group is the no Part B group. They have the no Part B problem. They were not enrolled at Part B at the time of the hospitalization, and they might have gotten that big bill from the hospital for the sticker price of hospital services. That's kind of the other group here. So it's sort of the either you had the nursing home problem or you had the Part B problem. Note that there's no length of stay requirement for the no Part B group. As long as you didn't have Part B when you were hospitalized and you meet the other criteria, you are in that group. So how to request a retrospective appeal. This is much more straightforward. Medicare created a form. There's a link to that form on this slide. A copy was also sent to you, and there was a link in the resources that you were sent. You don't have to use the form. There are also instructions which are linked to about what information to include. You send in the form or the information by mail or by fax. There is no online way to do it. It's only by mail or fax to the eligibility contractor that Medicare is using for this purpose. and the instructions are on that form. So there is some information that must be included, sort of the basics that you have to include. And then there are some information which you are highly encouraged to include. And we would say, send in as much as you can. Hospital records, nursing home records, the Medicare summary notices, any bills, and proof of payments that you made. Medicare has also said that the payments doesn't have to have been directly from you for the out-of-pocket costs. It could have been payments that a family member or a friend made for you. Those can also be counted as out-of-pocket costs. Send in as much as you can, and since you have some time, the deadline is not until about a year from now, as you'll see in a moment, I would encourage you to take the time to gather as much information as you can. And you will also have opportunities to supplement information later. And the eligibility contractor is also supposed to help people get required medical information. You can also include a written statement or statements, basically an argument from you or from a doctor about why the inpatient admission was correct. You'll want to argue that the doctor who admitted you as an inpatient got it right, and the hospital staff who reclassified you as observation got it wrong. So I won't go too deeply into the standard now, but this slide has language from the 2-midnight rule, which is in the regulations, and talks about when inpatient admissions are appropriate. And lawyer citations are at the bottom right. I would just say note that it is a forward-looking standard. Was there a reasonable expectation at the time of the doctor's inpatient admission order that the patient needed medically necessary hospital care crossing at least 2 midnights? And there was a slightly different standard for older hospitalizations before the 2-midnight rule. And as for when, Medicare is saying that people must request these appeals no later than January 2nd, 2026. We actually have a question into the government about this. We think that might actually supposed to be slightly later than January 2nd, 2026. So we will certainly publicize and update our materials if that is the case. But for now, this is what the government is stating. So it is a little over a year from now that there is this deadline for requesting the retrospective appeal. There will also be good cause reasons allowed for late filing under the usual rules that Medicare uses for good cause for appeals, and some of them are listed on this slide. So with the appeals not starting until January and having a full year at least until the deadline to submit them, what can people do now if they think that they're in the class? What we've been recommending for a while is to gather records and keep records that you're going to want to submit. And we've listed on this slide what are the likely relevant records. And on this slide, we've also listed a website with helpful information about requesting your medical records, because you'll want to see, usually there's often a written request involved. Sometimes you can do it online. Sometimes there are patient portals, but sometimes to really get what you need here, like the documentation of the admission order, documentation of the observation order, you may need to do a written request to get those precise things. The reason I listed that website, which links to various state laws about requesting medical records, is because there are some times when, although the general rule is that medical providers can charge reasonable costs for requesting your medical records, there are some states that allow for circumstances where you cannot be charged. So for example, here in Connecticut, if you're requesting your medical records in support of an appeal under the Social Security Act, they must be provided free of charge. Medicare is a program under the Social Security Act. And also in Connecticut, if you provide an affidavit stating you're not able to pay for your records, they must be provided free of charge. So this all depends on what state you're in, and I encourage you to check the law in your state for requesting medical records. Medicare understands also that there may be hurdles and challenges in getting access to older records, and it's stated in its final regulations for these appeals that the eligibility contractor must work with beneficiaries, providers, and Medicare contractors whenever necessary to help obtain needed information. And speaking of help, who can help or represent you? It's mostly the same rules as other Medicare appeals. You can appoint almost anyone you want to act as a representative. There is a form to do so, which is linked to on this slide. Some people are already authorized, like someone who has power of attorney to act for you. If the beneficiary has died, you will need to show authorization that you have authorization to act for the deceased person. So that would be documentation that you've been appointed to act as the representative of the estate, or if there is no estate, documentation of whatever rule allows you to handle the affairs for that person. This is all the same as it is for other Medicare appeals. But the difference from other Medicare appeals is that providers, they can't be parties to these appeals, and they also cannot represent beneficiaries in these appeals. However, they can assist, they can provide information, they can provide records, they can help you navigate the process. They cannot represent you. And I would also just mention Medicare has stated that you can call 1-800-Medicare for information in order to get copies of forms. Information will also be sent out to the SHIP programs, which provide free Medicare counseling nationwide. To contact your local SHIP program, you can go to the website, which is shiphelp.org, shiphelp.org, and find your local SHIP program. Some of those programs sometimes help people with appeals, but should at least be able to provide some information and direct you to forms and things like that. Medicare will be doing sort of its own outreach, and make sure that their representatives and SHIP programs have information about these appeals. So the actual process, there is this single entry point, the eligibility contractor, which decides only if you are eligible to appeal. Basically, are you in the class? If it says you are not, you get one more try, and then that's the end of that process. So you just have sort of one redo with the eligibility contractor to show that you're in the class. You can send in additional information. If information was missing, you can supplement it and try to show that if there's something missing, that you are in the class. If you then are determined to be in the class, that contractor will automatically forward your information to the appeal contractor, which will decide the substantive question. Was the inpatient admission correct? And then it is really like a regular Medicare appeal. And I will refer you to one of the handouts that came in the materials emailed earlier today, the flow chart made by our co-counsel Justice and Aging. There's an excellent flow chart which shows the entire process step by step, and kind of an infographic that shows what happens at each step of the process and shows the multi-level Medicare appeals process. If you are determined to be eligible to appeal, that's what's kind of different here. There's kind of this pre-appeal process where first the eligibility contractor decides if you're eligible, and then if you are, it goes to the appeal contractor. Then you have the standard Medicare appeals process, 4 levels. The third level is a hearing with an administrative law judge, or ALJ. That's generally the first time you get to talk to a human being. Those are usually done by telephone, and you can have some back and forth and talk to a person, and then you can go to one more level above that within the Medicare system, and then depending on how much money is at stake, you can also get review in federal court. At all stages, it's just important to follow the instructions very carefully, make sure deadlines are met, and follow instructions carefully for the appeals. Especially if you're going to higher levels, you may want to look into whether you want legal representation. And there is a link, I believe, on the Justice and Aging flowchart to a website that provides information about legal aid and other low-cost legal services organizations. Some of those provide help with Medicare appeals. There may be eligibility criteria that apply. Okay, I'll just quickly review some examples that I put up here. I won't go into too much detail just for time's sake, but I put three examples, which I'll let you review more carefully on your own. But the first example here of Ms. B is what I consider the sort of classic nursing home problem, a person who had a bad fall at home, went to the emergency room, was hospitalized, was initially admitted as an inpatient, reclassified to outpatient receiving observation services, then went to a nursing home. She didn't have 3 days as an inpatient and had to pay out of pocket around $10,000 for her stay in the nursing home. Her stay at the nursing home included skilled care of the type that is normally covered by Medicare, skilled physical therapy, skilled occupational therapy, and skilled nursing. We haven't really talked about what counts as covered care in the nursing home, but that is also something that to consider when you are thinking about appealing for coverage. And so is Ms. B eligible to appeal here? Yes, this is the classic kind of nursing home problem person. She should go ahead, request her records, and send in her request for a retrospective appeal. The second example is the classic no Part B problem, someone who went to the emergency room for severe stomach pain, was hospitalized just for a couple of days, didn't have to go to a nursing facility. That wasn't the issue, but this is someone who had Medicare Part A only, probably thought he was covered because Medicare Part A says hospital insurance, so you might think you would be covered in a hospital, but because he was reclassified from inpatient to outpatient on observation, he wound up with, it's as if he had no insurance at all. And hospital days in the hospital add up really quickly. He was only there for a few days and wound up with a bill for 15,000. He was able to work something out with the hospital where he only paid 5,000, but he still was out of pocket thousands of dollars. So he is also eligible to appeal because he had sort of the classic no Part B problem. He should get his records together and submit an appeal. The third example, I just wanted to make clear that there are some people, the people who were in the hospital, reclassified, didn't have the 3-day inpatient stay, couldn't afford to go to a nursing home, and unlike the first example, didn't have $10,000 to pay out of pocket, and just went home. This case does not help them. If they went home without getting nursing home care, they don't meet that criteria of admitted to a nursing home within 30 days of the hospital discharge. That's one of the criteria for being in the class. And in general, that's how Medicare appeals work, is you can only appeal for coverage of services that you actually received. So this judicial remedy does not help people retrospectively who did not actually get nursing home services because they couldn't afford them and just went home. I will be turning it over to my colleague, Wei Wei Kwok, who will talk about the prospective appeals, which will hopefully reduce the situations in which that will happen and may allow more people to get into a situation where they won't have to go home. So I will turn it over to Wei Wei.
Hey. Hello, everyone. Okay, yes. So we're going to shift now to talk about prospective appeals. And on this slide, we've referenced the regulatory provisions. Oh, could you go back one, please? Yes, on this slide, we've referenced the regulatory provisions that govern prospective appeals in case you want to review them in the future. Much of what I'll be talking about is based on these regulations as well as what the agency stated in the final rule. Next slide, please. So, next slide, please. So the district court's order requires the agency to establish and implement an appeals process going forward prospectively for eligible Medicare beneficiaries who want to appeal a hospital's decision to reclassify them from inpatient to observation. What's great about this is that going forward, eligible patients will have the opportunity to appeal their change in status on an expedited basis before even leaving the hospital. And that way, if they win their appeal, they'll know sooner that they meet the 3-day qualifying inpatient stay requirement to qualify for nursing home coverage. Now, according to the agency, the appeals process will be operational as of this coming February 14th. The appeals process will be available permanently from that day on. Now, I mentioned the expedited appeals, but a standard appeals process will also be available to eligible patients. Next slide, please. So, the big question, who will be eligible for prospective appeal rights under the new regulations? Well, an eligible beneficiary must be someone who is enrolled in traditional/original Medicare, but not a private Medicare Advantage plan. The person has to be admitted to the hospital as an inpatient, but then later reclassified specifically as an outpatient receiving observation services. In addition, the patient must fit into one of two categories. The first category would be someone who has stayed in the hospital for 3 or more consecutive days, but was classified as an inpatient for fewer than 3 days. And note that the date of discharge is not counted in calculating the 3 days. Now, this person may have an interest in appealing because the status change would effectively disqualify them from a covered stay in a nursing home after they leave the hospital. Now, the second category of person who has a right to a prospective appeal is a beneficiary who is not enrolled in Part B coverage at the time of their hospitalization. And this is because the status change would mean that they will be held financially liable for their full hospital bill. Next slide, please. Under the new regulations, hospitals must deliver a valid written notice to all eligible beneficiaries, informing them of their right to appeal the decision to reclassify them from an inpatient to an outpatient receiving observation services. Now, the agency has developed a new standardized notice that hospitals will be required to use, and it is called the Medicare Change of Status Notice, or MCSN for short. This notice is specifically designed to let eligible beneficiaries know that their status has been changed to observation and that their hospital stay will be billed to Medicare Part B instead of Part A. It lets them know that this change could impact their hospital bill because under Part B, they will owe a 20% copay for items and services, and that could end up being either higher or lower than the inpatient deductible under Part A. So one thing is, beneficiaries or their representatives may want to check with the billing department at the hospital to get a better idea of what the difference in cost would be. Now, people who have purchased a Medigap supplemental policy that covers their cost sharing may not feel any impact at all on their hospital bill. Now, the notice also informs patients who don't have Part B that they will be charged for the full cost of their hospital stay. And very important is that the notice lets eligible patients know that the status change means that Medicare won't pay for their skilled nursing home stay after leaving the hospital. And finally, this notice provides information about their appeal rights and how to request an appeal from the QIO or appeal contractor and what to expect. So the MCSN is a targeted appeals notice. It's delivered only to those beneficiaries who are eligible for this particular appeal. It's separate and different from other notices that these patients may get, including the MOON Medicare outpatient observation notice, which doesn't talk about appeal rights and is only required to be issued after someone has been on observation for 24 hours. Next slide, please. So when do eligible patients receive the change of status notice? Well, the regulation states that they must receive it no later than 4 hours before release from the hospital, but also they should receive it as soon as possible after they become eligible to appeal. So let's walk through a few scenarios on how this could play out. In scenario number 1, we have someone who was formally admitted as an inpatient on Monday. The hospital changes their status to outpatient observation on Tuesday, the next day, and then they are discharged on Wednesday. Well, in this situation, the change of status notice is not required because the patient was not there for 3 days, since we don't count the day of discharge. Now, in scenario number 2, we again have someone who was admitted as inpatient on Monday and is switched to observation on Tuesday. But this person is discharged on Thursday. So in this case, the patient should get the notice on Wednesday because they would have been in the hospital for 3 days at that point. But definitely they shouldn't get they need to get the notice before 4 hours prior to their release on Thursday. Now, in scenario number 3, we have someone who has no Part B. They're admitted as an inpatient on Monday, their status is changed on Tuesday, and they're discharged on Wednesday. Here, the patient is eligible to appeal immediately because they don't have Part B, and they should be given the notice as soon as possible after their status is changed, and it doesn't matter that they weren't there for 3 days. Now, a notice is valid if it's timely issued and the eligible beneficiary or their representative has signed and dated the notice to indicate that they have received it and can comprehend its contents. If they refuse to sign, the hospital can make an annotation indicating their refusal to sign. Next slide, please. So what happens next? How does an eligible patient appeal? Well, they have a right to request an expedited determination by the QIO that has an agreement with the hospital. And they must make their request in writing and faxed or by telephone before they're released from the hospital. After receiving the appeal request, the QIO must examine the relevant medical records. And the hospital has to supply all the information that the QIO needs as soon as possible, but generally no later than by noon of the day following the request. At the QIO's discretion, a hospital can convey information over the phone, but has to keep a written record of anything transmitted verbally. The QIO must also ask for the views of the beneficiary or their representative, who must make themselves available to discuss the case, and this is typically done over the phone. The patient may, but is not required to submit written evidence to be considered by the QIO. The QIO also has to allow the hospital to explain why the reclassification was appropriate. Now, once it receives the requested pertinent information from the hospital, the QIO must issue a decision within 1 calendar day. The QIO has to notify the patient, the hospital, and the nursing home, if the patient's already in a nursing home at that point, of its decision by phone followed by a written notice explaining the basis for the decision, the payment consequences, and the beneficiary's right to request an expedited reconsideration. Now, for payment purposes, the QIO's decision is binding on the beneficiary, the hospital, and the Medicare administrative contractor that processes claims. The only exception is if the beneficiary is dissatisfied with the decision and decides to appeal further. Next slide, please. So an eligible beneficiary can timely request an expedited reconsideration from the QIO, either in writing or by phone by noon of the day after they were initially notified of the QIO's decision. The QIO, in turn, must offer the beneficiary and the hospital an opportunity to provide further information. And again, the beneficiary or his or her representative must be available to answer any questions or supply information that the QIO requests. The beneficiary and the hospital may, but are not required to submit evidence at this level of appeal. Now, the QIO has 2 calendar days to issue a reconsideration decision after receiving all pertinent information, and they must notify the patient, the hospital, and the nursing home, if applicable, of the decision, followed by a written notice explaining the decision and the beneficiary's right to appeal to the next level, which is an ALJ hearing, if they're dissatisfied with the decision. So I wanted to note here that beneficiaries are not protected from financial liability while pursuing these expedited appeals. Financial liability protections apply to patients pursuing expedited appeals of hospital discharges, but not to patients appealing their status change. However, the hospital is prohibited from issuing them a bill until after the expedited process is complete. Next slide, please. So we've covered expedited appeals, but what if an eligible patient wants to appeal after they leave the hospital? Well, the regulations state that an eligible beneficiary can still make a standard or untimely appeal request at any time. So that's a direct quote from the regulation, at any time. So they can appeal to the QIO after they've left the hospital or when they're already in a nursing home, or even after they have left the nursing home and have foot the bill for their nursing home stay. In response to these requests, the QIO has 2 calendar days to issue an initial decision and 3 calendar days to issue a reconsideration decision if requested. Now, billing protections do not apply to these standard or untimely appeals. And I'll just say here that after the reconsideration level, expedited and untimely appeals will follow the regulatory requirements and timeframes for standard Medicare appeals at the next 3 levels of review, which are the ALJ, the Appeals Council, and judicial review levels. Next slide, please. Who can help with prospective appeals? Well, again, beneficiaries can appoint an authorized representative, such as a trusted friend, relative, or an attorney for these appeals. But as with the retrospective appeals, providers cannot act as appointed representatives for a beneficiary in these appeals. But they can lend assistance and support by providing records, answering questions about status change and the appeals process, or helping patients connect with their local SHIP program, contacting 1-800-Medicare or the QIO. Knowing what is documented in the medical records can be helpful in these appeals. And at the beneficiary's request, the hospital must furnish a copy of or access to any documentation that it has sent to the QIO. And that is due by the close of business of the next calendar day. And they may charge the patient a reasonable amount to cover the copies and delivery costs. Next slide. So finally, what criteria will be applied to these appeals? What should and will the QIO and other reviewers be evaluating to decide if someone met the criteria for inpatient hospital coverage? Well, one thing is that they will make sure that there is a doctor's inpatient order. The hospital must formally admit a patient after a doctor orders inpatient care to treat their illness or injury. Okay. Another key inquiry is whether the treating physician had a reasonable expectation at the time of admitting the patient that the person needed medically necessary hospital care crossing at least 2 midnights. And this is known as the 2 midnight rule. According to CMS policy, inpatient payment is appropriate if the 2 midnight rule is satisfied. Therefore, the reviewer will be deciding whether the admitting physician's expectation was reasonable based on the documentation in the medical record. And factors that will be considered in this decision will include, what was known at the time about the patient's medical history, their medical needs, the severity of their clinical signs and symptoms, the medical predictability that the patient would suffer an adverse event. Now, if it looks like the hospital kept the patient for tests or studies that normally would be outpatient services or weren't available over the weekend, they would likely be evaluating whether the patient was so sick that the hospital couldn't risk sending the patient home. So finally, I just want to add here, a little note to emphasize that it's the clinical information available at the time of inpatient admission that is key. And this is important because sometimes people go to the hospital quite sick with concerning symptoms and medical histories, but they might unexpectedly improve after a day or two. But the agency's policy specifically states that QIOs do not take into account other information, for example, test results, which became available only after the admission decision was made, except in cases where considering that post-admission information would support a finding that an admission was medically necessary. So I hope that's helpful, and we provided a citation there in case it could be helpful in people's appeals. Okay. Thank you. I'm done.
Great. Actually, we know it's question and discussion time. You want to close out that screen share and we can just get you guys up there. Now, do we have any brave hand raisers who want to ask aloud? That is an option here. And until then, this was answered in the chat by one of our attendees, but I thought you guys would want to know. 9 or 10 people, I think, so far have asked, why do hospitals do this? And I think it's a pretty simple answer.
Why do hospitals was the question?
Yep.
Okay. Well, yeah, I mean, this was a big question that came up in the court case. It's mostly because they are trying to comply with Medicare requirements, and they have been audited and told you have to pay money back. They are paid less for observation services than for inpatient services, but Medicare was very, very aggressively auditing hospitals and telling them that a lot of their inpatient admissions were not correct, did not meet inpatient criteria, and going back and recouping to the tune of millions and millions of dollars claims from hospitals. So hospitals have we're sort of going the other way and putting a lot of people in observation status. And there's just been a lot of push-pull between Medicare and the hospitals on this issue. It really comes down to payment and sort of aggressive auditing by Medicare. But the fact that Medicare says, sort of there is a right and wrong when it comes to inpatient and outpatient was one of the important principles in the case. Do you have anything to add to that, Wei?
No, that's pretty much what I would say too.
We had a few questions on the assistance portion of this presentation. For example, we have a ship counselor who asks, how much can they do to assist beneficiaries? And we had someone else who asked, how am I going to get this right? Sorry, I'm trying to find it. If someone wins an appeal, had out-of-pocket nursing home costs, the nursing home is responsible to reimburse the costs. Can the nursing home submit a claim? And then we had someone ask, what if the beneficiaries passed away? Can their beneficiaries appeal?
Okay, so the
Right.
first one about
Ship,
ship.
beneficiaries,
Okay,
and a nursing home.
so the ship, I think as for what SHIP programs can do, I think that you would have to talk to your program about that. There are, I think Medicare is supposed to be sending information out to the SHIP programs about these types of appeals. And, so I would ask your SHIP director, whether it's your local SHIP director or maybe your state director about that. And then I think it depends on your program as to how far you individual SHIP counselors go to help towards helping beneficiaries, because I know I have encountered some SHIP programs where they do actually like sort of help individuals with appeals, and some they might point them to legal aid programs or other attorneys who help, or just kind of help them navigate the process. So I think that depends on the individual SHIP program. The second about the nursing home scenario where someone gets a refund from the nursing home, I would point the person who asked that to the regulations that are cited in the presentation and the final rule that is cited. There are rules, very, sort of technical rules about what the providers can do in terms of rebilling. But I'm also going to go back to my upfront disclaimer about what our expertise and knowledge is, and we just can't provide information on sort of the rebilling aspect of this. But it is in the rules, and so providers talk to your consultants and billing consultants about that, because there is information about it in the rules, in the regulations, and the preamble that was put out by Medicare. And what was the third one, Matt?
It was if somebody passed away, can
Oh, yes.
their
So
beneficiaries
yes.
appeal?
Yeah. So as with any other Medicare appeal, someone who has authorization to act for the beneficiary can submit an appeal, and that can submit an appeal, and then in terms, as we discussed during the presentation, can say, I'm the authorized representative of the estate, or here's what gives me authorization to act, to handle the affairs for this person. And then in terms of like who gets the refund, which I think what the question might have been about that, I think that will depend on how the person arranged their affairs, and so whoever is in charge of the estate will have to figure that out based on how state law, or however the person's will is drawn up. I mean, that will probably just depend on however the individual set up their estate.
All right, thank you. Someone asks, wasn't there something weird with this during COVID? If they remember correctly, they were told they could appeal, then they couldn't, then they didn't have to.
Well, so during COVID, the CMS for a while suspended the requirement that people have a 3-day inpatient stay. And it was really something that nursing homes had to do. It wasn't really something that a patient couldn't go in and say, I invoke the right to not have a 3-day stay. If the nursing homes could do that, from what I understand, I'm not completely expert on this, but so during the public health emergency as declared by the government, there were people who were able to go to a nursing facility with Medicare coverage despite not having a 3-day inpatient stay. So therefore, they wouldn't have this problem. So I think, if they don't have the problem, then they won't need to have this solution.
Yeah, and from the hospital side, nothing really changed as far as like
Right.
status. Yeah, status at the hospital.
Right.
We always hope that one doesn't have the problem. You mentioned this, I believe, but I know this is going to be a question from more than one person. We have someone who asked, do the same rules apply for Medicare Advantage plans?
Yeah, no, so the case is only about people getting their Medicare coverage through original or traditional Medicare through Medicare Part A and Part B. Medicare Advantage, which is also called Medicare Part C, is not covered by this lawsuit. So it's just Medicare Part A and Part B.
Awesome, thank you. I think this also might have been mentioned, but it's a very full presentation. We went pretty quickly. So how does someone who's trying to do a retrospective appeal that might be years old, who didn't have a 3-day inpatient stay, find out if it was due to a reclassification from inpatient to outpatient or just not being admitted as an inpatient?
Yeah.
What do they have to seek?
It's a good question. I think that may be, especially for older cases, it could be challenging. I think the main thing is requesting those hospital records, and when you request them, making sure that you are specifically requesting any status orders, and then following up if you don't see anything about status orders, following up with the hospital and finding out what the status orders were. So it may not be something that sort of comes on the first try. So try to request them. And if you don't see them, follow up with the hospital. If you get, if you request orders, you may see them in there. Wei Wei, do you have any suggestions for sort of like how wording or how that can be requested besides saying, all patient status orders?
Oh, I mean, I think, yeah, being specific about that. But also, I think being very clear about timeframes and trying to get everything if possible, because sometimes those orders are just like hidden. You really have to find them
Right.
in the mess of
Right.
things.
And
It
I
could
was
just be 2 lines written, in a
right.
page hidden among,
Right.
100 or more other pages. So.
And I'll say about those like patient portals, like those are often not complete. From my experience anyway, like, oh, I'll just go to the patient portal and download what's available there. And you can get some, like you can, and discharge summaries and things like that are helpful. But some of these things like the inpatient admission order and then like the observation order, as Wei Wei said, maybe sort of buried more deeply into the system than something you might get from just a patient portal, which are sort of just the more superficial sort of, here are the records of your treatment and your discharge notes. Those are more sort of internal. So which is why, sort of simply going to the patient portal, it might be a starting point, but you might have to do sort of a more formal written request and some follow-up to get the actual orders.
Right, thank you both. We had several questions on the differentiating the two types of appeals here. Claire, could you clarify once again the situation where what does this say? You are in the hospital, you're being, they say discharged too early, but I think we mean change in status there, and you're advised to contact the BFCCQIO, those quick appeals. Who would arrange to get you another night in the hospital? And then this other type, which is change of status is involved. So they're talking traditional discharge appeal versus change of
Right.
status.
So, right. The appeals that have been around for what, I don't know, a while now are hospital discharge appeals. There's also discharge appeals from some other types of care settings. They've been around for a while. They're called expedited or fast appeals, and you're given a notice, and they're sort of similar to what Wei Wei was talking about, where you're given a notice, you think you're being discharged too early. Here's the number of the QIO. You can call and say, I disagree. I don't think I think I still need to be here. And you get a quick decision. That's about sort of, do you need to continue to be in the hospital or not? That's a different scenario. What
And
we're
those,
talking,
right.
yeah, I'm sorry, go ahead, Wei.
And
Yeah.
sorry, and just to put in there that, and those are for people who are inpatients. They have that right They haven't been switched. They haven't been switched to any other status. They're inpatients.
Right. And then what we were talking about today was appeals for people who are reclassified from inpatient to observation, who, before had no appeal rights at all and on that issue. And we're just told, like, okay, you're on observation. There's nothing you can do about it. You get that moon notice. You're on observation, nothing you can do about it. And you don't have the 3 days inpatient stay to go to a nursing home, nothing you can do about it. Now, if you get into a situation where you're there for 3 days, but not 3 days as an inpatient, you have to get this new type of notice, which also gives you a quick appeal right, but it's on a different issue. It's on should the hospital have reclassified you from inpatient to observation. And if you succeed in that, then you can get that qualifying 3-day inpatient stay, which would allow you to go into a nursing home with that qualifying 3-day inpatient stay.
Thank you. We also had a question on the timeline for the not quick appeals. You said that that's still an option with this process. What's that timeline like? How long is not quick?
So like on the if you're talking about the prospective appeals,
Yes, sorry, yes.
untimely, right? So literally, like and we've never seen this in Medicare, and they went beyond what the court required. They are allowing appeal anytime. So
Yeah.
you can years later, you can appeal, and you can be, and this is a good thing for people who, let's say they sort of had the old classic situation where they went into a nursing home and wound up just, think they were dealing with too much and just had to pay out of pocket for it. And, then realized, hey, I don't think I really should have had to do that. I was in the hospital for 5 days. I shouldn't have been put on observation. You can still appeal.
They can
And you can,
start the process.
yep.
Yes. They can start that process by contacting the QIO that has an agreement with the hospital that they went to.
Excellent. Awesome. Hey, speaking of years later, and going back to the getting records, what do you do if a hospital didn't keep records for a certain time back? It goes back, almost 20 years now.
Yeah, it will be hard, and Medicare acknowledges this in the regulations. Get as much as you can, and we would suggest also getting, write your own narrative about what happened, and if you can, from any of the providers who are still around, try to recreate your own narrative of what happened as much as you possibly can and submit that. So they, like I said, they are required also to help you try to get the records. So between that and submitting whatever you have, write down your own narrative of what happened, and anyone, if you had family with you, who can write their narrative of what happened,
Notes that
doctors.
you took at the time,
Yeah,
notes
absolutely.
that you took on paper and
Anything like that that you can submit, go ahead and submit it. And I would also like reiterate, if, there's any, just try it, try it. If there's any question in your mind about whether you're eligible, we would just suggest that you try submitting. And, you'll have opportunities to supplement and submit more later. There's nothing to, it doesn't cost anything. There's no like fee to appeal or anything like that. I mean, there's time and possible fees for getting records and things like that, but there's nothing other than that to lose by trying.
Thank you for that. I know we are over time. We still have a lot of folks who are hanging on with us, and we still have a lot of questions out there. I have three sort of other clumps of similar questions. One, can you clarify again? Because people are asking, what if you are just outpatient all the time? What if you're outpatient and then switch to inpatient? Is there anything that you can do about that?
No, not unless then you're then switched to observation. So it's only the inpatient to observation reclassification that that generates this right to appeal. So if your observation the whole time, not a right to appeal. And if your observation to inpatient, there's not a right to appeal.
Unfortunately, what we thought. Several people are asking, how do they find the QIO? How do they get the contact information?
That will be listed on the notice, and it sort of depends on where you are geographically. So the hospital has to list that on the notice, the same way they do now for discharge appeals. But it will, yeah.
Sorry, and a follow-up, we've had several people say, you know, I've seen moon notices from hospitals that are inaccurate, that don't have a contact number. What do you do in that case if they're not actually following the rule?
Okay, well, they will be getting new notices beginning February 14th. The hospitals will be required to be issuing eligible folks who are eligible for these appeals. They'll have to get these new notices called the Medicare change of status notice, and those will include the QIO's information.
If the hospital messes up, I mean, I think, you know, you can call 1-800-Medicare to file a complaint. I'm trying to think, you know, contacting SHIP or
Right.
1-800-Medicare would
They'll know the
probably,
QIO. Yes.
yeah.
Yes.
Thank you
So
very much for that.
local SHIP program or 1-800-Medicare, yeah, to explain the situation, and they should at least be able to give you the correct QIO number for where you are.
I believe QIO will also turn up in a simple search on Medicare.gov.
Yeah, it does depend, like, you know, yeah, geographically
Where
where
you
you
are.
are.
Yep.
Yeah.
And the last clump of questions that I've seen is kind of a big picture question. A couple people have asked, why not just approve post-acute nursing care for anyone who's in the hospital for 3 days? Has anyone ever tried to just change it that if you're in 3 days, you get to go to the nursing home?
Yeah, great way to sort of end the webinar. We are still very much participating in advocacy for comprehensive reform on this issue. Our colleague Toby Edelman is part of an observation status coalition that has been advocating for years that just any time in the hospital, you know, whether it's observation, whether it's inpatient, should be counted towards the 3 days. It would be a very clean way of solving this issue so that it wouldn't affect beneficiaries, it wouldn't affect their coverage. You know, this whole slicing and dicing of the time into observation versus inpatient didn't happen until Medicare started getting very aggressive about these audits. And you know, it might have been an unintended effect, but you know, people were starting to be really adversely affected in their ability to get to nursing facilities. And whether it was intended or not, you know, Medicare should, you know, we think, take that simple solution and count all time toward the 3 days, or eliminate the 3 day stay. Another option would be eliminating the 3 day stay, which many Medicare Advantage plans do. And now with more than half of Medicare beneficiaries being in Medicare Advantage plans, you know, there's a great number of patients who don't require a 3 day inpatient stay to get subsequent nursing home coverage. And if it's good enough for Medicare Advantage, you know, we don't see why it's not good enough for original and traditional Medicare as well. So we are continuing on that bigger picture question to advocate for comprehensive observation status reform as well, on sort of the general advocacy front. And, you know, on this litigation front, we also wanted to make progress where if the rules aren't changing, at least some people have the right to appeal and get coverage. If Medicare is going to say sort of there's a right or wrong answer to whether you're observation or inpatient, then people should be able to make an argument for themselves and get coverage where they can. So we're sort of fighting this on a couple of different fronts. And we
Thank you.
will have another webinar about this topic. I'm sure that there will be more questions coming up as the processes get started. So I believe January 22nd will be our next webinar
Yep.
that we're hosting, and Justice and Aging, I believe, will participate in that one. And there will be a webinar hosted by NICLR, which is for elder advocates for older adults, in February as well, I believe February 26th. So keep your eye out for more as these appeals get started.
Yep. One note on the why don't we just count all 3 days? There's usually annual legislation proposed in both the House and the Senate. I know Representative Joe Courtney in Connecticut sponsors a bill every year to try to do just that. So contact your legislators. It matters. So thank you all today for attending. And thank you to Allie and Wei. This was a lot of information. I'm glad that we will be having a follow-up webinar on this information. That will be January 22nd at 2 p.m. Eastern, that time, not 3. And you can watch our weekly alerts and check our website for updates and registration links. As noted earlier, you will receive a follow-up email today with links to the slides and the recording of today's presentation. You'll also get a little survey, so please do let us know how we did there, and what we might do next time. Thank you all once again, and I will now conclude today's presentation.